Okay, so this is 105, so I guess we might as well get started. I'm happy to see everyone logged in. Sherine, no pressure. We're just excited to hear everything you have to say about the matrimonial home under Ontario family laws. Besides it just being a special place where people have a lot of memories as families, you and I recognize that there's a special treatment that it's given under the law. For those of you who have not had the pleasure of working with Sherine, she's an amazing family law lawyer at our firm. She's very experienced with these matters, and she comes with very interesting perspective because she's been on both sides of everything matrimonial home related. So Shirine's been with our firm for a few years now, so lots of experience, great positive attitude, and her clients just love her. So that, I mean, I guess that just really says it all in the results right there. So Sherine, I'm not without further ado, like those of you that want to know a lot more about Sherine, her bio's on our website, and but today I want her to jump right in and just tell us about matrimonial home, what's so special about it, and if you have any questions, we'll go over those kind of at the end. And if you don't mind, Sherine, I might need to jump in every once in a while if I feel there's something, maybe an urgent question. I would monitor the chat. So for those of you that are uninitiated to Zoom, depending on what kind of screen you're using, at the bottom or at the side, you would see sort of the features, and one of them is the chat feature. So you could type in any questions there, and I would relate them to Shireen, or at some point at the end, we can do a question and answer session as well. Okay. All right, Shireen. So myself, and it's all up to you now.
Thank you, Angela. So today, obviously the topic is the matrimonial home. What makes it so special? What are the special rights that spouses have relating to the matrimonial home, and things to consider when dividing the matrimonial home and for sale of the matrimonial home when you're selling that asset. So ultimately, what is the matrimonial home? That's the most commonly asked question. People come to us and they think that a property qualifies as a matrimonial home or doesn't understand that the home that they're speaking of actually has special characteristics and special rights. So a matrimonial home in Ontario, it actually has to be in Ontario. First of all, the property has to be situated in Ontario for it to be considered the matrimonial home. And you can have more than one matrimonial home, but I'll talk about that a little later. But ultimately, the matrimonial home is considered a premise or really a property that is ordinarily occupied by the parties as their family residence. So you can have more than one matrimonial home, as I said. So if you have a home in the city, you can have a cottage, as well. And as long as you ordinarily occupy these properties at the date of separation, they will come under the umbrella of that definition of what is an actual matrimonial home. So if you have property that is outside of the province of Ontario, so if you have a cottage in Quebec, unfortunately, that does not qualify under the term of really a matrimonial home for our purposes today. So that's really what a matrimonial home is, and what kind of special rights are attributable to the matrimonial home. There are several. So ultimately, the most important thing is that I think the most common misconception is that, okay, my spouse owned this property prior to us actually being married. So I don't have an interest in the property, or, it's their property or I only get the increase. Unfortunately, for that person who came into the property with that home and it actually meets the definition of a matrimonial home, they don't get to deduct the value as they would in other assets at the date of marriage. So for example, if you have a property that you guys were, that was owned by, let's just call him Greg, and then Cindy, he owned it prior to the date of marriage, married Cindy, and then Cindy started to reside in the property, and that became their matrimonial home. It existed on the date of separation. Under normal circumstances, if this was any other property, then he would have been able to deduct that value, and Cindy would have only been entitled to the increase in that amount. But in this circumstance, she would actually get to share in the value. Now, depending on how title is held, which I'll get into a little later as well, that would determine the division upon separation. But ultimately, no, the spouse, even if they own the house prior to the date of marriage, will not get a deduction for the value of that property. So each spouse will ordinarily ordinarily have an interest in that home. Either if the title is solely held, then it's really a property that's divided upon equalization. And if the property is jointly held, then the parties are entitled to equal distribution and division of that property specifically. Another important factor is what makes the matrimonial home so special is that the parties both have equal rights of possession. So you can't just say, you know what, we're separated, I'm just going to change the locks. Unfortunately, it doesn't work that way. And I have people come to me often, and I'm sure Angela can relate, that, we'll just say, you know what, I don't want her here, or I don't want him here, and I'm going to change the locks. So unfortunately, without a court order giving you what's called exclusive possession of the matrimonial home, you can't just make that decision. So I'll talk about what the court would consider in actually making an order for exclusive possession. And you can actually have exclusive possession of a home, even though you're not on title to the property. So I'll talk about that in a little bit, but ultimately, both parties share the right of possession for the home, and you can't limit their use without a court order or an agreement otherwise. So that's a common misconception that most people have. In addition to that, your spouse can't, even though you're muted, sorry.
I was just going to have at that point a little bit more, because that's something that's very surprising to people, right? So if it's not a matrimonial home and you're living in another property, say a rental, for example, I'm imagining that obviously subject to things like, is it the right moral decision and stuff like that? But from a purely legal perspective, you can ask the other person to just leave, right? Because you're the lease owner. But in a matrimonial home, it doesn't matter if it's your home, if it's your family home, if you've had it for 100 years, you can even be asked to leave that home, and the other person that doesn't have title to the home would have the right to remain in that home for as long as necessary, if they have the court order, obviously, for that. Is that correct?
Exactly. That is absolutely correct. And yes, people are often surprised by that. But you did touch upon an issue that I didn't bring up. But a matrimonial home doesn't actually need to be a property that's owned by a spouse. It can be a leased or rented premises. So just like, you don't have to own the piece of real estate for it to be considered the matrimonial home. So again, even if it's a rented, even if the spouse is paying the entire rent for that amount, he cannot basically oust you from the property without a court order, or vice versa. So thank you for that. So that was also a very important consideration that a lot of people, I think, are presently surprised by. So thank you. In terms of kind of also, okay, so if the non-titled spouse is still allowed the equity in that property, and the right of possession also comes with that is the right to encumber or sell that property. So often people don't understand that, no, your spouse actually has to get your consent, regardless if you're on title. Obviously, if you're on title, they would have to get your consent very clearly. But even if you're not on title, they should not be able to encumber or sell that property. Now, of course, there are situations where someone would potentially lie and say it is not designated as the matrimonial home, and therefore they don't need spousal consent, which is usually what is required by the real estate lawyer closing that transaction for selling that home. The courts have set aside transactions where a spouse has gone ahead and basically sold a property that is actually considered the matrimonial home without the other spouse's consent. They can set aside those transactions. So the parties need to be very wary of the fact that you can't just because you want to or you own this property, if it's considered the matrimonial home, unfortunately, you do have to get the other spouse's consent to be able to encumber. So if you want to register any other additional line of credit that's secured onto the home, a second mortgage, all of those things require spouse's consent, regardless if they're on title or not. So that's an important consideration.
Okay.
It's also important, to understand that the courts, when looking at the sale of the home, so often our question is, because it's the most significant asset for most people who are separating, it's probably the most dealt with issue. I'm sure Angela can relate, that everyone asks, okay, what do? We have the home. Now, it obviously depends on how it's held. If it's joint, it's pretty simple at that point. It's divided equally. If it's the spouse who owns solely that home, you can have a trust claim, but I won't get into that today. But ultimately, that would be divided in the terms of equalization. So the full value would go to your spouse's net family property and the debt as well, and would be shared upon in the division process. So I hope that didn't go over everyone's head.
I think it did. Do you want to go? Do you want to go back a little bit? I followed you, but I'm like, maybe everyone isn't. So
yeah. So normally when parties separate, really married spouses are entitled to what's called equalization, which is, in the simplest way put it, I take spouse A's net worth and spouse B's net worth, and whoever has the higher net worth is required to equalize the difference, pay half the difference between the two.
Equal, so, literally equal, right?
Literally equal. So, and then everyone, I think the common misconception is, okay, so I get 50% of the boat, I get 50% of the car, I get it can work out sometimes that way, but it's not that literal. So it will take into consideration, okay, the assets. So if it's the matrimonial home, as I said, they're not entitled to a date of marriage deduction, which in most separation circumstances are a great thing because it reduces your net worth. So it means that you're less likely going to be the party paying the other an equalization payment. Or if you have date of marriage deductions, it would be a less of an equalization payment if you were required to pay one. I hope that makes sense.
It makes sense. It's just that you're saying they don't get that though. They don't get the benefit of that date of marriage deduction, right?
Yes. So yes. So normally if they had a property, they would be entitled to only the increase from the date of marriage to the date of separation. But with a matrimonial home, the law is very clear that no, there is no date of marriage deduction. Your spouse is entitled to the equity in that value of that home, either the value through equalization or half the amount if they are actually joint tenants or tenants in common for 50% of the share or whatever allocated shares they have. But regardless, it's the matrimonial home that has very special considerations.
Let's split the matrimonial home and kind of talk about it a little bit more, and this vision aspect, because as you said, it's one of the areas that we focus a lot on. So just separate it as, let's talk about the matrimonial home where only one person on title, and then after we're done beating that drum, then would go where it's joint ownership. So just talk about Greg being the only owner of the matrimonial home.
So are you talking in terms of division?
In terms of division, yes.
Okay. So in terms of division, Greg would include the assets, or really the matrimonial home, the full value on the date of separation, and would include the full debt on the date of separation. Now, sometimes this automatically would have him having a higher net worth. So it's accumulated with all his other assets. So if he has a pension, an RSP, and then credit cards, all of that are factored in. And whatever the amount at the end comes to the I guess net worth, we'll call it, which is really considered your net family property. Let's say his net family property is $200,000. And that's considering everything, his assets on the net value, which would take the asset, reduce the debts, add everything in. It's like, the simplest way to put it, I actually think, is to take a picture of basically your situation at the date of marriage and the date of separation and the recent date, but really you're focused on the date of marriage and the date of separation. So take a snapshot about all of your assets, all of your debts, and really see the difference between the two. Again, with the matrimonial home, you don't get the deductions. So if you are able to get essentially all of that into what we consider financial disclosure in this circumstance, would be preparing a financial statement. From there, you would see the value of the home would be attributed there, and you would see that the value, including all his assets. So it gets factored in everything. Whereas if Greg had jointly owned the home, it would be 50% to Greg and 50% to, I believe Cindy was the same partner we were using. So 50%, and it would be 50% attributed to her on her net worth, and essentially 50% on the value for him. And same with the debt would also be split, and any other registered mortgage or line of credit secured against that property.
So the
So I hope
shocker,
that answers that.
yeah, the shocker, I think, for a lot of people is that on the date of separation, it doesn't matter if the property, as of the date of separation, not any other snap point in time. It doesn't matter if the home is in Greg's name alone or if it's in him and Cindy's name as joint owners. They would divide the value of that home equally.
Yes.
Okay. All right. So I threw you off there, but
Yeah, so I think that's the complicated part is, so oftentimes people will ask me, well, okay, is it better if it's in his sole name or if it's in my sole name or if it's joint? The reality is it's difficult to kind of paint a picture without having a full complete picture of your assets, right? Because if you have a lot of assets and you attributing the matrimonial home to solely in one party's name, then you may even fare out better. The other spouse might fare out better in an equalization, but ultimately it's difficult to determine. But if you want to secure that you're getting that 50% interest, no matter what happens, obviously subject to other trust claims and things like that, but you want to be registered as on that title, on that home. You want to make sure it doesn't mean that you don't have the equal rights of possession, and that's regardless of how title is held, but to make sure that you want 50% of the value of that home, even after the date of separation until the home is sold, you want to be registered as joint tenants or as tenants in common for 50% of the share. So that's kind of the beauty of being on title, in like the simplest way.
yeah, no, it makes a lot of sense, Sherine, because look at properties. So for files and family law files are notoriously slow sometimes. And if you owned a matrimonial home in 2019, the example you gave us could mean the difference with hundreds of thousands of dollars. On average, at least I know in Durham region, most homes that are up to the $1 million mark have seen significant increases of up to 200, 300,000 with nothing being done to the homes. It's just the way the market is right now. So if you owned a home in 2019 that was worth $1 million, now it's worth 1.3 million. If you're Greg and you own the home alone, then that means all you have to share with Cindy is $1 million,
Exactly.
right? But if Greg and Cindy are both on title, then good for them because they both get to share the full 1.3. So that's really significant, right?
Exactly. I've actually like recently had a discussion. So ultimately, I think people are surprised that it's the value that ends at the date of separation if you're not jointly owned on that property. That it's at the date of separation is what you're sharing in. So unfortunately, files do take longer to, some files, obviously, some issues can take longer to settle, like the matrimonial home, because of its importance and emotional significance. And it's usually the largest asset. So if you can't come to an agreement, ultimately, you could spend months to even over a year or two to really settle that issues. Obviously, it could take longer depending on how reasonable you can be, but ultimately, yeah, it's a big consideration. So if you won't share in that increase. So you're waiting all that time to settle the home and you don't get the value in that time if you're not a joint owner of that home. So it's a very important point.
Yeah.
So I wanted to kind of touch upon, so if your spouse, I think this is also not a commonly asked question because it's not as common as a scenario, but if your spouse is the major shareholder of a corporation and that shareholder, which is essentially your spouse, owns that property that is attributed as your matrimonial home, it will still be considered the matrimonial home for the purposes of the Family Law Act. So I think that's a common thing that most people may not be aware of. So they think that the business may be protected, obviously subject to, the variation by a court, but ultimately that's usually how it's considered. And I did talk about, so you've now separated, you have the matrimonial home, and maybe it's going to take some time to sell, but you and your spouse are in a contentious situation, or through circumstances, you just can't live together. Now, one party can apply for an exclusive possession, which is having exclusive possession of the home, either on an interim, so on a temporary or a permanent basis. The court will factor in several different things when making such an order. The most common is the best interest of the children. So if you have children that are in the home and, Sydney, let's just say, is the primary care parent, and, Greg has the funds, is not paying maybe spousal support if she's entitled, or child support, they may give her that order for exclusive possession, especially where there's contentious issues. The court's also going to factor in the financial position of each parties, and the court's mostly concerned with both spouses' ability to maximize the equity in the property. So sometimes people will make that more emotional and significant argument that I should, have the exclusive possession of the home because I lived here, I don't want to sell it. Unfortunately, when it comes to actually selling the matrimonial home, the court's going to consider what is best for each party in the circumstance, given the basic formula for them is, okay, how can each party or each spouse maximize the equity in that home? And oftentimes it usually results in either a sale or the other spouse buying out the other's interest in the home. So that's a common issue that comes about. So, I have a client that comes to me and there's the matrimonial home. They come to an agreement that one spouse will buy out the other spouse. So how do they do that? The reality is, like, you need to get either, you could always come to terms on your own, but ultimately it would be to assess what the actual value of the matrimonial home is and what the other person would be buying your interest at. So if you're able to secure financing and actually purchase the other person's interest in the home, great. Oftentimes it's not as simple and we don't agree to the value of the home, for example. And, you guys will have competing appraisals. And at that point, if your spouse doesn't agree to you buying out their interest at what they believe is a lower rate or a low fair market value, then the reality is the home would most likely be listed for sale in this circumstance. And if you have other issues that are pending, sometimes the proceeds for the matrimonial home will be held in trust by the real estate lawyer. So if you have competing claims for equalization, or there's existing retroactive or ongoing child or spousal support, or really other issues that need to be considered, then the reality is the proceeds will be held in trust if one party feels like that a release would prejudice their position.
Okay, so Sherine, I wanted to just jump back a little bit to something you had mentioned earlier when you talked about a corporation. Even though a corporation owns a home, it could still be a matrimonial home, right? So I wanted to add something there because it's interesting. I find that even where it's a family home, for example, or one party owns the matrimonial home with a friend, it doesn't have to be the full 100% interest belonging to the spouse. So if your spouse has 50% interest in the matrimonial home, you don't get to share in, the full value of that matrimonial home. You only get to share half of whatever his interest is, right?
100%. That's actually an interesting point. So not just a corporation, but let's say your spouse jointly owns the property with another individual. Mm-hmm. You're entitled to half his share, essentially, in that value. So it's not that you're getting, even though it's special and it's the matrimonial home and it's the home you resided in, if it's jointly owned with if your spouse jointly owns that house with someone else, you're not getting the full 100% of the value. You're getting half of their share in the calculation, either through equalization or if you go against through equalization. But yes, ultimately, that's a very important point. So thank you. And I think what's also important to note is often is the children and in circumstances with the matrimonial home. So what's best is do you sell the home? Do you keep the home? Do you have to automatically sell the home? And the reality is you can come to any arrangement that it's agreed to between the two of you, right? So there are often times where, the home needs some work and the children, let's just say they're 2 years or a year from finishing school, and they would rather not uproot them and, have them complete the school year in the matrimonial home, and they'll come to any alternative arrangements that they can. So that's not uncommon. And that's a commonly asked question, like, can I do that? Of course you can. But they also have to, it comes with a caveat that they also have to agree, or else the court would have to weigh in the considerations if it's appropriate to order the sale and if it's fair to both spouses in the circumstances. Sorry. So I was wondering if maybe anybody had a particular question.
Nobody, but I do. So, because it's something that I've been asked, or it's something that we grapple with. And I think it's important for people to know when it comes to the value of the matrimonial home. Does it always have to be, by appraisal? Is that how we know the value?
No, so I mean, again, it's if you guys come to an alternative arrangement, it's usually the fair market value for the matrimonial home. But ultimately, if you get a real estate opinion, which if both parties agree, then it's relatively a little cheaper than getting a formal appraisal. Oftentimes it's pretty much amicable on the value. Now, again, this is like if you both agree to get competing appraisals, or if you get a real estate opinion or a jointly retained appraisal for the property and you agree that that's the value. Now, the issue stems from when you don't agree that that should be the fair market value. But no, you don't have to, in the shortest answer, you don't have to get an appraisal. You can get a real estate opinion, or you can agree between yourselves that this is the value by even doing your own research. I have people who come to me and they say, you know what, a house down the street, it sold for about $850, similar in comparison. Sorry, 850,000, just so for people wondering, but and it has very similar features, very similar comps to essentially your home. So they'll use that value, because sometimes people don't want to spend the additional money to get the value. And for me, if my client disagrees with the value of the home, I ultimately say, well, the reality is if you get an appraisal and you believe it's a lot more, that's thousands of dollars more that we're talking about. So it's a small price to pay for basically a larger value that we're looking at.
Absolutely.
I do have a question here,
Okay.
if you allow me.
Absolutely.
Can you tell me in matrimonial home, if the deed is on one person's name, what about the mortgage payment? Do they have to both share the mortgage payment?
Yes. So thank you for your question. Actually, so after separation, because it's a joint asset, both parties are obligated to pay.
No, I think he said it's in one person's name.
Oh, one person's name?
Yeah, so
Yes.
title is in one person's name, and he's wondering if the other person obligated to pay the mortgage after the date of separation.
So no, because they're not sharing in the increase. So why or would they contribute essentially, unless that's the agreement? If you agreed that you're going to share whatever value after the date of separation, then great, then they should have the obligation to pay for the increase. But if they shouldn't be maintaining a property where it gets essentially cut off at the date of separation, its value, and it's fixed in stone that that's what they're getting, they shouldn't be responsible for maintaining the asset.
But would your answer change? And I'm guessing it's a no, if you found out that that person had exclusive possession of the home? The
No.
other party, yeah. So I think that's where working with a lawyer comes in, because then you have to think strategically, right? So, and this even ties back to, and I'm going to say something about the value of the home, but just to be on Side's question. So if you're on the deed, if you have title to the home alone, and again, let's go back to Greg and Cindy. So let's say Cindy alone has title to the home, and now they're separated. Greg doesn't have to, even if he used to contribute before or he never did, doesn't matter. Greg has the right to say, I'm not going to contribute to this asset because I'm just not going to benefit from it. Exactly what Sherine just explained. But the other angle to it is, Greg, you're living in Cindy's house free of charge. So that's not fair. You're tying down her equity. So there's one of two things. Cindy can consider occupation rent, And Greg would be thinking, well, does the other thing you need to think is, do you owe child and spousal support to Greg, right? So Cindy, while you're thinking, well, Greg isn't paying anything towards the home, well, do you owe him anything financially? Because if you can't, if it turns out that it's a no, that you don't owe Greg any financial obligation, then we might want to speed up the process of getting Greg out of your home, because you can't make him contribute to the asset, right? So that's sort of a strategic point there. But Sherine, I know you were kind of on the value of, before I move forward, actually, Sai, does that answer your question or not?
Yes, I did. Yes, you did. I appreciate it. Yes.
Oh, okay. All right. So jumping back to where you were in terms of the value of the home, I can personally say there's been times in my practice where I don't care what an appraisal says, right? Because I think my clients can get more. And especially in a market like this, I know this was the case sort of, I think, I don't know, when the crazy Toronto markets were, I think it was like 2016, and the bidding wars, like kind of like what seems to be happening these days. And I know that at that point, I didn't care what an appraisal said, because fair market value was insane. So a person is entitled to fair market value, and you have to understand that an appraisal, and that throws people off all the time. And they get so stuck on what their appraisal says, and they're wondering, why would my spouse not accept my offer to buy him or her out? Like, we got an appraisal, like I'm an appraisal, and it's neutral. And it doesn't matter how many times you say it, appraised value is not necessarily the same with fair market value, because we know that in the marketplace, there's several factors that can influence the buying decision beyond just what the appraisal says, if there's a leak in the roof or whatever, those types of things, right? So Sherine is right. If there is no argument, obviously we appraise, we do whatever, but I just had to throw it out there, because if anyone ever said, well, why aren't you using the appraisal? It's because sometimes I don't think it works as fair market value. Do you want to weigh in, Sherine?
Oh, actually, like 100%. I've had this issue come up plenty of times. And yeah, like the court would assess the situation. They're not going to say, you know what, this is what the appraisal said, you must buy them out. That's not what they're going to consider. If you honestly believe that the court is really concerned about maximizing the most amount. So when they tell you, okay, when you get that order for a sale of the home, it's to accept the best offer. And they want you to get the best, like truly the best offer. So yes, again, I have clients that don't agree with the appraisal. Sometimes it's more, if it's a banking institution, if it's an appraisal to get, more lending, like they think that the interest was to lower the actual value, and it's not, just an appraisal done to value the home in its current state, then of course, like that's a consideration. But ultimately, if that person or that spouse says, no, you can't buy out my interest, it's worth far greater. And I actually want to take my chances on the market because it's crazy. Well, right now it's crazy out there. So, I mean, everything's going well above asking. So yeah, like if this was me, I would definitely want to put my home I would definitely want to list the home for sale.
Absolutely. Absolutely. So we did have a couple of questions on there. Okay, there's a lot more, but I'm going to try to group them together. So Abbas is asking, I don't like the realtor my wife chose to list the home. Can I disagree? That's a tough one.
I mean, it is tough. Of course you can disagree. Everyone can disagree on really anything. That's the simplest way to put it. But I mean, ultimately, you need to accept the offer anyway. You both do. So, I mean, if the realtor is someone you can't work with, then I would put that to your spouse and discuss getting a new realtor at the same time. So,
why I think the difficult one is, and I don't want to get too specific with Abbas's situation, because this is a public forum, but let's say the home is owned by only one person. And I've been in this situation. So, let's say Abbas's wife owns the home, and she's brought this realtor, and Abbas, whether or not he's on title, he has a right to have the equity in the home, right? And he doesn't think this realtor is doing a good job. It's interesting because yes, he has a right to maximize his interest, but at the same time, You know, his wife might say, well, it's my home, I'm on title. You're, you know, should you really have that much say over an asset that's not yours? So, I mean, I think there's room for argument on both sides, and it would really depend on the circumstances of your case, or depending on what side Sherine and I are. But yeah, the simplest way, I think, which what Sherine said is, yep, you can disagree, and it just depends on what the facts are. So Kathy had a question. She said, I'm looking into taking advantage of the real estate market in Durham because I know that properties are being sold for approximately 200K over asking. That's true, but do not have a separation agreement in place yet. What are my options in the meantime before I get a separation agreement signed? I've tried on numerous occasions to have him sign it, but 2 years later, we are still without one. Is there a legal document that can be signed to just release his rights and interests in the property instead of a separation agreement? Selling the property and taking advantage of the real estate market is my main concern here. So, Sherine, this is a long one, but I think Kathy owns this property alone, is what I'm guessing. Or, you know what, I'll let you, I don't know how you're interpreting that question, but you can
I'm
weigh
interpreting
in.
that in so many different ways. Ultimately, I think I wasn't clear if, okay, so Kathy is the only one on title. Thank
Mhm.
you. So are you saying that as part of the settlement, or really that
No,
you're
there's no settlement. So she wants to sell and there's no
not
settlement.
agreeing? Okay, ultimately, I mean, it's not an uncommon issue. I could tell you it happens all the time. But in that circumstance, if he's really not cooperating, unfortunately, that's probably where you would have to get a lawyer involved to kind of move things along, or start an application to the court to order the sale of that home.
That's the fastest. If I were you 2 years after, I would absolutely, you know, I'll absolutely just go to court. That's what I'll do, because the market's really great right now. And again, depends on your circumstances. And again, just because it's a public forum, we don't want to be too detailed on your specific situation, but you might want to go to court because yes, you're not allowed to sell that home without his consent because it's a matrimonial home. I'm not sure if you were logged in the beginning, and when Sherine kind of gave us the rundown on what we can or cannot do. And one of it is encumbering the home or selling. You need that consent. So you can't do anything without that. And if you know, and what you guys could also do, and this is where maybe getting legal help can be of assistance to you, if he can even just agree on the home being sold and maybe holding the proceeds in trust, then you guys can take advantage of this current property market, and you don't touch the funds and it just stays there until you deal with all the other issues. If you put that to him and he still says no, we don't know when we're going, how long this wave is going to last. And if you don't take advantage of it now, who knows, maybe prices even start to go down. So I would go to court if I were you, Cassidy, under the circumstances. So Sherine, we have a follow-up here. Could my spouse, so first, Abbas, thanks you for answering his question. And he's wondering if his spouse could take him to court for not accepting the value that the realtor said, oh, they're joint owners and it's 500,000 less than all other realtors said. And we received many offers when we first listed and he refused them. Now we have only one offer and it's very low and it's $50,000 less. Oh, this is a pretty,
Interesting.
yeah, you're jointly, wait, did I see we're both on title somewhere?
Yeah, so they're joint owners of the home.
Yeah, so no. If you, oh, this is interesting. The truth is, when there's no agreement, I think we should just preface it by saying if there's no agreement, you can either mediate the issue or you can go to court. That's what it's going to boil down to. Whether you're jointly, whether it's jointly owned or whether it's solely owned, correct? Because it's the matrimonial home, you don't have a right to do anything. So if it's, I mean, if there's all of this roller coaster and the realtor is not allowing you accept offers and this and that, then this is time for you to go to court with this. right? And it depends on what the full picture is. It could just be something as simple as asking the court to appoint another, to allow you appoint another realtor. And a lot of times, and I know Sherine does this as well because it's a practice that we do all the time, is whenever we go to court for matrimonial home related issues, we always add that they should accept the first reasonable offer to avoid this sort of thing that's happening here, right?
Just to add actually on, usually, I mean, depending on how unreasonable the other side is being and cooperative when there's a real estate agent involved and you are losing out on, significant offers, we also add a potential claim for damages against that person for really getting a very low, I guess, a low ball offer and missing out on a very, I guess, good figure for the home.
Oh, that's
also something to consider. The courts don't really award damages too often, but again, if we're talking about a significant amount and your spouse acted unreasonably in that circumstance, or the other owner of that property didn't allow you to accept their first reasonable offer, that's going to be a consideration you definitely want to bring to the court's attention.
Absolutely. And about to say what's damages. Yeah, this is a very creative sort of solution. It's not standard in family law, but sometimes somebody just has to pay. And in the simplest of terms, the damages is just making sure that the party that's responsible for you losing out on whatever it is compensates you. So if you've lost out, if you feel like because of their maneuvers or their delays or whatever, you've lost $100,000 that you could have made on the sale. And Cassidy, that would be, Kathy, that would be an option that's available to you as well. You can say, okay, I was going to sell, and you might want to gather your data now. So look at comparatives, keep materials on the prices, on the price increases that's been happening in your neighborhood, so that if you lose money a year down the road because somebody is just being unreasonable, then it would go out of their share. You're going to say, we're selling for you with this 50,000 less, she's got to pay you back. Now, remember that technically, if you're selling for 50,000 less, that means you lost 25,000, not 50,000, because it's only half that's yours. Then yeah, so that's a very creative solution for sure. And I know Shirine's very experienced in doing these things and asking for damages, and the truth is it's often effective in just making sure that the other side does the right thing. Most times we don't even need to.
I mean, it's just really more of like, okay, let's get this moving, and it doesn't look well. It doesn't sit well with the other party knowing that they could be liable for really not being cooperative. And sometimes court costs aren't as effective as, seeing a claim for damages, for example, for the amount that you could have sold that property for. So yes, I would have to agree with you, Angela. It is pretty effective. And oftentimes we don't actually have to use it.
Yes. So someone had a question about rent to get, and I kind of skipped that because I was trying to batch the realtor questions. So we have, so this is Home Computer's question. And Home Computer says, if both spouses live in a Toronto community housing rent geared income apartment, leasing is in the name of the male spouse only. So this is a male and a female spouse in a Toronto community housing rent geared to income apartment. In the case of a separation, which spouse will leave that place? I mean, do you want me to say anything here? Do you want to go first, or I can?
You can go for it.
So I'm just going to, in the simplest of terms, ultimately, it would have to be, I'm thinking the male spouse whose name is on the lease is the lease owner, and he would be the one that would eventually keep the place because he's the one that has the lease. That's what I'm thinking. But in the interim or right after separation, and again, I don't know if you were here in the beginning when Sherine sort of talked about things with the matrimonial home, there's the right to possession. So if at the end of the entire process, the male spouse might be the one that gets to keep the house, but you can't, because the apartment is in your name only, doesn't mean that the other spouse has to move out immediately. Sherine, is there anything you want to add?
That's exactly what I would add. There are circumstances where people come to us and, they secured a really good rental, right? And they're like, no, we've been paying like a reduced or a fixed amount for this rental income. I don't want to be the one that now has to find another place when this is like a pretty good deal that I'm paying monthly and I'm pretty used to it. Oftentimes, unfortunately, in that circumstance, you would have to apply to the court to factor in that consideration. But there's only so much the court could do with third party people. And, they can't make the landlord add you on the rental agreement, but the right of possession and those things, those are very clear that, they're not going to be able to limit your use and enjoyment of that property. I mean, other than maybe just driving you crazy, but without getting a court order, they won't be able to just kick you out.
Yeah. Okay, so you have another question from Fatima, and she says, can she refuse to share in the cost of improvements to the home?
100%. I mean, it's so often that people don't have the funds, and that's what they're going to consider. If you're unable to share in the improvement, now, if these are necessary improvements and they're small improvements that will help you both maximize the value of the property, the court actually may tell you that, you know what, you should share in the cost if they're small. And again, if they're subject to, if you're able to afford it, they'll take into consideration everything. But no, the property to be sold as is usually what the court will deem necessary. They're not going to say, yes, make this $500,000 home a beautiful $1 million home and have a great, it's unreasonable. The reason you're selling property is because you need access to your capital. So the court's going to consider that as a very fundamental kind of purpose for you guys even needing to sell the home. You guys need the maximum value. Now, of course, if there's small improvements like painting and things like that, again, they can't compel you to make those improvements. And sometimes, it's very rare that I've ever seen the court say, yes, spend $20,000, $30,000 renovating this property. The reality is it's subject to your financial position. But again, you could absolutely refuse to share in the cost of the improvement of the home. And in fact, if that spouse goes ahead and does improvements to the home without your consent, that's another situation that we commonly deal with, because they're going to be seeking a reimbursement for half the value. And usually that gets paid from the net proceeds at the time. But essentially, if it depends on your circumstance, if you agree, of course, if they're small and you guys maybe cap it, because sometimes we'll have an agreement that, they'll share in the improvement, but it'll be maximum, $10,000 that they'll use. And that would go to painting and whatever. And from your share, when you receive them, you'll reimburse the other party your share, which would be $5,000. So I hope that answers your question.
Yeah, what I found effective too is if you have a real estate agent and they will tell you just the basics that need to be done to have the house ready to sell, right? So if it's something like that, I would not oppose it, because usually they know what they're talking about, and those little improvements can sell the home. For a higher value. Now, if they're asking for you to produce cash now, you could say no. If the other side has the cash in hand, let them pay for it and they can be reimbursed, as Sherine mentioned, from the sale proceeds, right? But they can't make you give out money from your resources at that particular time if it's not something that you're comfortable doing. Right. And if that's the case, then let it be sold as is. But if they're fine with doing the improvement and capping it the way Sherine said, not just making it all fancy just for the sake of it, just the basics to make the value, to maximize the value, then absolutely. But then maybe they should be getting their money at the back end. Okay, so Sherine, we have only about 6 more minutes. I don't know if there's any other things that you wanted to add, or if we kind of killed it with all the questions.
I feel like we covered a lot, even topics I didn't intend to cover today. But yeah, I think the only thing I didn't mention is the matrimonial home is only for married spouses. I think that comes like pretty obvious to most, but some people will come and, be in a common law situation and believe that this property is their matrimonial home. Unfortunately, only married spouses get that special designation and are able to actually use that designation and get all of those rights and entitlements relating to the matrimonial home. So I hope that was pretty clear from the onset.
Yeah, that's a good one.
But I believe that's everything. Do you have anything, Angela?
Yeah, I wanted to, I don't know if you talked about the right of first refusal. Now, I know that's a topic in and of itself, but I think if you could just touch on that very briefly in the context of selling the matrimonial home.
Yeah, so if the matrimonial home is jointly owned, there is no right of first refusal. And the courts are very clear that, you don't get that option to refuse. Again, this goes to kind of the consideration that I told you, that the court would want to consider that you maximize the best amount you can for the value of the home. So they're not going to allow you to obtain a right of first refusal in that circumstance. So in fact, they would actually want you to get the best possible price without interference from the other spouse.
Okay, so, and for those that are not sure what right of first refusal is, it's usually one person, say, I don't even know, simple numbers. So $500,000 house, and you guys disagree on the value, and now you decide that you want to list it on the market. And one spouse is saying, well, I want the first option to buy that house when it's, regardless of what offer is made, I want to have the right to, I want to be the first to get it, but the courts wouldn't do that. As a spouse, all you're entitled to once that home is listed is to make the best offer possible. So there's no consideration for you being a spouse and saying somebody offered, 600,000, I'm going to give 590. The courts don't care. You better make sure you're offering 610,000 or something like that. So you have to give the best offer, and they would not, there's no right of first refusal.
Yeah, you're basically bidding in the open market, just as if you're any other potential purchaser. And that's often sometimes when my clients want to, or a client of mine would want to purchase the home, or a particular party really wants that home. Unfortunately, we're unable to agree on the value, and so the home is listed for sale. Then they better be, willing to bid on the open market. Unfortunately, for most people, the market is, in this circumstance, I think people would just want to back out, depending on how significant and emotional significance, because I know that's kind of the driving point sometimes, or maybe even the hard work that you put into the home. Let's say, over the years, you've decorated it, you've put really everything you have into a home, and to you, it doesn't really matter if you're paying above, what you believe is fair market value for the home. Then, like for you, it's that kind of comfort. So that's kind of the emotional significance that obviously comes with, having the matrimonial home.
Mm-hmm. I should actually have everyone go watch a video that you and Anissa did. This was years ago. Sherine and one of our other lawyers here, Anissa Datu, actually, they did, what would I call it? Kind of like a round table.
For the matrimonial
conversation, it was an argument. So one person took the legal position that the home should be sold, while another person took the opposite side and said, well, I have sentimental value, something. I can't remember what it's called. I think it's called to sell or not to sell, the matrimonial home.
Listed, or love it or listed, I think.
Oh, love it or listed. Yeah. So
yeah.
I see Abbas said he watched the video and it was good. Yeah, it was some solid argument. So if you have any concerns about whether the home can be sold and things like that, that's a good one to watch. Actually, I had wanted Sherine to also talk about selling the matrimonial home and the rights to do that, but I think we're going to probably need a full hour for that sort of conversation. So I will save sort of the rights to sell the home, if you're a joint owner versus if it's solely owned. Everything sale of the home, I think we would leave for another conversation because we don't have enough time for that today, unfortunately, but that's a good subject for sure. Dahlia had a quick question here, Sherine, and I know we have only about a minute left. Oh, thanks, Abbas, for sharing that YouTube link. Oh my God. So thanks for that. So, so Dahlia said, what about other properties purchased when you are common law? I'm not really sure I understand. If you buy properties as common law spouses, there is no matrimonial home designation to it. It's just a property. If you own it equally, then you split it equally. If you don't, you don't. Now, there's ways around that. That's the most,
Many.
yeah.
I think this is kind of an interesting, very, very complex, more intricate like part of the law. And that's with respect to common law couples and trust claims and, you know, those equity principles. So I think this actually would be maybe a nice topic to have a full discussion on specifically. But just to answer, I guess, like very briefly your question, if your purchase property, just like Angela said, if it's jointly owned, then it's going to be split that way. If it's solely owned, subject to any trust claim, it's going to be that spouse that owns that property.
Okay. So I am making a note here for, we should have a discussion sometime soon about family homes for common law or for common law spouses. Okay, Sherine, so that's a promise there. You have to be back to kind of discuss that topic. So thank you, everyone. Thank you so much, Sherine, for all of your the information that you've shared with us today. I hope you all found this helpful. And on that note, I guess we're going to sign out, right, Sherine?
100%. Thank you so much for everyone. Stay safe and take care.
All right.